How to Avoid the Four-Headed Monster of Estate Planning and Elder Law on Amazon. Oh, hey there, folks. Elder Law Care Attorney Patrick Kelleher. Thanks for joining me today, folks, at elderlawcare.com. Folks, today's question is how to choose an executor or personal representative for your will-based plan or your trust-based plan, or what I like to refer to as your treasure chest. Folks, today I'm going to answer that question. How do you choose an executor or personal representative or legal fiduciary for your estate plan, whether it's your will or your trust or your treasure chest, okay? Really, really important consideration, folks, and I talked about this recently in my new book that I'll be releasing shortly on the top 15 elder law questions. And we talked about this in one of the latter chapters of that book. How to pick a suitable fiduciary, a helper, whether it's personal representative, executor, trustee of your will, trust, or treasure chest. So important. Folks, pull up your chair, get your pen out, get your notebook out, because the success of your estate plan will oftentimes depend upon who you pick as your trustee, as your quarterback of your playbook, okay? So folks, you'll typically, when you read about this subject matter, typically it'll be folks that have financial acumen, might be an accountant, might be a CPA, might be the family attorney, and that's a son or daughter, mom and dad, Bill and Mary, want to pick as their personal representative, trustee, executor, which is the older term. I advise my clients that frequently pick someone who is suitable, with good acumen, someone who you think could run the treasure chest after you become disabled, after you become incapacitated, after you pass away and go up to your cloud. Someone who's going to follow your instructions that you outline and delineate in your will, in your trust, to the letter of the law. They're not going to change things around in their best interest, what they think is right. They're going to actually follow your instructions, your written instructions, okay? That is imperative. That is of paramount importance, folks. Otherwise, if they disavow your written instructions and they get off course as the fiduciary trustee, then they become what they refer to as a bad fiduciary, and they're not doing their job. And hopefully they get back on course and they follow your instructions. When I advise our clients who to pick when we design their trust on the whiteboard, yes, all their standard practical things that you think of. My son or daughter, they're a smart person, they're well educated, they have a formal education, they have a good job, they're an accountant, they're a financial advisor, they're an insurance professional, they're an attorney, whatever it may be. All that is well and good, and I'm going to share with you a big key, folks, from my experience that most people do not talk about, but we know from professional and personal experience. That person that you're picking with all those skills on paper, they look good on paper. That person, folks, pull up your chair real close, get your pen out. My recommendation, you have to make sure, in order for your plan to run right, they also have to have a good heart. That's right, folks, you heard it. They have to have a good heart. They have to respect all the beneficiaries of your estate plan. Even if they don't like them or they have a conflict of interest, they have to put their egos in all those other issues and things aside, because their job as the executor, personal representative, trustee of your will and trust and of your treasure chest, not to act in their own best interest or what they think is right. Under trust law, they have a fiduciary duty of loyalty to act in the best interest of who? Your estate, your treasure chest, and your beneficiaries. So I've talked about this in other programs. I talk about it in my book as well. Really, really important. Yes, that your fiduciary, helper, executor, trustee have those traditional, practical skills to manage money and things of that nature, cross the T's, dot the I's, but they need to have a good heart. They need to communicate with all the beneficiaries. They need to have transparency, good communication, and above all, respect. Give each and every beneficiary, whether it's their favorite or their non-favorite, all the same legal rights as the other. Really, really important, folks. From my experience, I often say to our clients, you're the expert on the family. Think back to early years. What was that person like in your family? Are they able to get along with everybody else? And if they were not able to get along with everybody else, or only able to get along with a few and not others, really, really think twice about who that person should be to be your trustee, executor, personal representative, and you may want to put a pause on the person that you're thinking of initially. Because from my experience, even if you have the best pilot flying in that treasure chest, from my experience, they can fly it into the side of the mountain and put the family on the back side of the cloud, which is family conflict and family strife. You don't want to do that, folks. You want to do what I talk about in the book, the 3 Ps: protect what you work hard for, preserve the value, and then pass it on as a meaningful legacy, which is the front side of the cloud for your loved ones. They're all looking up at you, singing your praise, rejoicing you later in life. You don't want to be on the back side of the cloud with thunderstorms and lightning and family fighting. Folks, hope this video is helpful for you today. If so, scroll down, post a comment, post a question, because a member of our Elder Law Care team will get back to you as soon as possible. Thanks for joining me today at elderlawcare.com.